Hi, my name is Tom Kosman. I'm an attorney with South Coastal County's Legal Services in Hyannis. This tape results from a talk I developed last year in conjunction with the GALE Fund, answering a question that was posed to me by a client in Provincetown who was wondering whether or not he should, now that it was an option, wed his same-sex partner. I will cut right to the answer that all lawyers give to all questions, which is, it depends.
You want?
By this I mean that the decision to marry for any couple is a distinctly personal one, and that couples with similar circumstances could reach different decisions about it. What I'm hoping to do with my talk to you today is to give you some issues to think about as you contemplate the decision that might not have otherwise occurred to you. We're filming this in the spring of 2015, and I want to caution you that the United States Supreme Court will be ruling later this year on it, so check back and bear in mind that many of these issues will continue for some time after whatever that decision is. Now, I don't speak as an expert about marriage. I speak of as a veteran of it. I've been married 35 years this fall to my wife. But what made things different for us is that marriage was always an available and consequently seemingly logical option, and it wasn't something that we necessarily reflected on. With same-sex couples, it's an interesting conundrum because you have a bifurcation of the emotional commitment that may have taken place years ago and the contractual, as it were, commitment that can be made presently. So it's not an especially romantic way of doing a decision, but it's what society has afforded us. And to make it even less romantic, you're listening to a lawyer describe your options. To fully appreciate the situation we find ourselves in today legally, it helps to have a little bit of an understanding of the legal precursors to this. The initial challenge to a ban on same-sex marriages was originated in Minnesota back in the 1970s in a case called Baker, but it went nowhere. The case that began us on our current path began in Hawaii in the 1990s. There's a challenge on Hawaii's ban on same-sex marriages based on Hawaii's constitution, which prohibited sex-based discrimination. The case went up to the Hawaii Supreme Court, which agreed that their constitution forbade a ban on same-sex marriages. However, rather than instituting same-sex marriages in that state at that time, the court stayed their decision while affording an opportunity to the government of Hawaii to present an argument why it was not in the state's best interest to have same-sex marriages issued. They raised the usual objections, sanctity of marriage, raising of children, the fact that such marriages would not be recognized by other jurisdictions, none of which the court found to be convincing. However, during the stay, opponents of same-sex marriages organized in Hawaii and passed an amendment to the Constitution specifically banning same-sex marriages. This is a course that many states subsequently followed, and it's also what led to DOMA, the Defense of Marriage Act. So the Hawaii case led to the Defense of Marriage Act, which permitted states to refuse to recognize same-sex marriages from other jurisdictions. It was passed in 1996. It also defined marriage specifically as involving one man and one woman. In response to that, 36 other states passed what were known as mini-DOMAs. Some states obviously were more receptive to the idea of same-sex coupling anyway, and in the face of DOMA, the state of Vermont in 1999 created same-sex civil unions. It was an attempted solution that satisfied no one. Proponents of same-sex marriages viewed it as a second-class sort of sop, and opponents, as you might suspect, refused to acknowledge the propriety of such unions at all. In November of 2003, however, the Massachusetts Supreme Judicial Court, in the Goodrich case, recognized that under our state constitution, again, similar to Hawaii's decision, our ban on discriminatory acts by the state included the fact that you could no longer ban same-sex marriages. So the first marriage licenses in Massachusetts for same-sex couples issued on May 17th, 2004. Today, about 4% of all Massachusetts marriages are same-sex partners. Opponents to same-sex marriages in Massachusetts tried the same course that opponents in Hawaii did, which was to pass a constitutional amendment prohibiting it. However, they were unable to do that, and the law went into effect. So Goodrich legalized same-sex marriage in Massachusetts, and a few other states followed suit, but it was still unrecognized nationally, with all of the attendant issues that created concerning benefits, taxes, and so on. So finally, we come to the case of Edith Windsor and Thea Spire. They were a long-term same-sex couple who lived in New York. In 1967, they had exchanged as engagement commitments brooches. And finally, in 2007, were able to wed in Toronto. In 2009, New York State began to recognize foreign same-sex marriages. That is to say, if a marriage was legal where it was performed, New York would recognize it. But the federal government still didn't recognize same-sex marriages. And when Miss Spire passed away, she had had MS for many, many years, and Miss Windsor was not only her partner, but her caregiver, and, as it turned out, her sole heir. And when Miss Spire died, Miss Windsor was hit with a federal estate tax bill of $363,000, which would have been nothing had she been her spouse. Rightly enraged, she was treated as a friend who'd been named sole beneficiary rather than spouse. So she challenged that because she should have been able, as a spouse, to inherit it at the federal level and tax-free. Ms. Windsor sought redress in the federal courts, and in 2013, in the spring, the Supreme Court said the tax treatment that she was subjected to violated our Equal Protection Clause of the Constitution. So, since the spring of 2013, federal recognition of same-sex marriages has obtained, but regulations have been slow in evolving. Interestingly, the VA has been quicker than Social Security, and there's still the question of all those states with constitutional prohibitions. This is one of the things that we hope will be resolved by the Supreme Court this spring in 2015. But in the meantime, and for some time after that, until this sorts it out with all of these mini-domas, we need to be aware that we're an itinerant society, and even if you get married here, you may well find yourself in a jurisdiction that doesn't recognize same-sex marriages, and that can lead to problems. And I should mention that even though there is federal recognition of this and agencies have responded accordingly, it's important to recollect that these agency decisions are administrative and could be easily reversed by a future administration, depending again on what the Supreme Court does this year. So now that we've defined the context of marriage, what is it you should start to consider? Well, again, a lawyer isn't going to have the most romantic advice for you, but virtually all advocates in the area stress that the single most important thing that a same-sex couple contemplating marriage should do is to enter into a prenuptial agreement. Reason for that is twofold. Marriage is a contract, and absent a prenuptial agreement, which can spell out the terms and conditions of the contract between the parties, you are bound by the contractual provisions that state law imposes upon a marriage. The difficulty for same-sex marriages, until it's resolved on a national level, is that while you may be married here, if you relocate to a jurisdiction that doesn't recognize it, divorce is not going to be an option. And again, being unromantic but realistic as an attorney, almost half of all marriages, whether same-sex or opposite sex, end in divorce. A prenuptial agreement can anticipate and address some of the problems that arise in attempting to terminate a marriage in a jurisdiction that doesn't recognize same-sex marriages. You can agree to file, if jurisdiction is available, in a state that recognizes same-sex marriages. Absent that, you can agree to submit the matter to arbitration or mediation, and you can have the terms and conditions spelled out. Second reason that a prenuptial agreement is important is, as I mentioned earlier, you have a bifurcation in many instances of the emotional commitment, which may have been years ago, and the contractual commitment, which is being made presently. So, because divorce settlements are based on the length of the marriage, among other issues. A proper prenuptial agreement should recite the actual length of the commitment. For example, it should say this prenuptial agreement in anticipation of a marriage in 2015 memorializes a romantic commitment that dates to 1964 or 73 or 81 or whenever you were lucky enough to find your partner. Another area that prenuptial agreement needs to address is the issue of children of the marriage. The non-biological parent should always make an attempt to adopt the child, and that would address many of the issues. But a prenuptial agreement, in the absence of the availability of adoption, which does occur from time to time depending on state law, a prenuptial agreement can address many of the issues that arise in the split up of a marriage. Things like not removing children from the state, not obstructing visitation, providing for the education of the children, and so on. All of that can be addressed in the prenup. What advocates in the area of same-sex marriage like to see is a belt and suspenders approach, which is to say, making every effort to be doubly sure that you have addressed issues and that you should assume nothing. With children, the worry is that if you relocate to a non-recognition state, or even if you have an accident in a non-recognition state, say while visiting Disney World, you want you, as the child's parents, and not the legal presumptions of the host state to make determinations for your child. So if you have a situation where there's one biological parent, the non-biological parent should make every effort to attempt to adopt the child. Non-recognition states do recognize adoptive parenthood. This may not be an option. Recently, a couple with a child who was a result of artificial insemination petitioned New York State for the non-biological parent to adopt, and they were refused. New York said that it was a child of the marriage and consequently presumed to be just that, and an adoption would be unnecessary and redundant and therefore wasn't available. But if the non-biological parent is the one with a child at Disney World, you can have issues making healthcare decisions. So, as part of the belt and suspenders approach, you want to be sure that the biological parent executes what we call in Massachusetts a caregiver authorization affidavit, pursuant to Massachusetts General Laws, Chapter 201F, which empowers the non-biological parent to make healthcare and educational decisions for the minor child. If there are no children, you still want to give each other healthcare proxies and execute living wills, too. Remember the Terry Schiavo case. As well as pre-planning your own funeral. Disputes frequently arise over where to bury someone. And if you haven't made the preparations yourself, the decision in many states devolves on the next of kin. And if you're somewhere that doesn't recognize your marriage, your partner's parents or siblings may be their next of kin.
Go.
So what about benefits of marriage? Well, supposedly there are 1,138 benefits of marriage as calculated by the General Accounting Office. That would include things like qualifying for the family pass at the National Seashore. There are clear benefits in areas like Social Security, the Veterans Administration, pension law, and also estate tax, as we discussed with Ms. Spire earlier. It's not the case with income tax. In most instances, a married couple, regardless of the sex of the partners, is going to face what is familiarly known as the marriage tax. There's never intended to be a tax on marriage, but the effect is that there is. Our tax code dates back to the 1950s, when typically a married couple had one wage earner. And so when you got married and had to file as married, which continues to be the case, if you're married you have to either file jointly or singly, but as married. And in either instance, the fact that today's society has largely two wage earning partners in the marriage results in, for most people, a higher tax rate. There are obviously some exceptions to that rule. And you really need to run this by an accountant. But if, for example, one partner has a lot of itemized deductions that they can't realize because of their income, it may be beneficial. So there's not a flat rule on that. The one thing you do need to know about income tax is that if you have been married for a while, Until the change in the federal law, you weren't able to file as married, and you ended up paying a penalty for things like if you were getting your health insurance through your partner. You can go back for up to 3 years and file amended returns. Again, you want to run it by your accountant, and you can cherry pick what years there are. But if you have been married for a while, and the requirement to go back and file amended returns seeking relief is that you have been married under your state law. But if that's the case for you, it may behoove you to ask your accountant to take a quick look and see if filing an amended return makes some sense.
Go.
As to estate tax, and remember this is what triggered the Windsor decision, the federal limit for taxation of an estate is $5.25 million per person, or $10.5 million for a married couple. In Massachusetts, we start taxing estates at $1 million, but we have an unlimited deduction for spousal bequests. It's what's called the Melinda Gates provision. You can be really rich and leave everything to your spouse tax-free. If you're in a situation where you're subject to a taxable estate, obviously you need to have a formal estate plan and not base what your decisions are on this video or brief advice that applies to a broad segment of society because your circumstances are special. The federal recognition of same-sex marriage also gives you options under Social Security. You have to be married for at least 9 months before your spouse dies in order to qualify for survivor's benefits. You don't get deathbed marriages. Or at least a year to get spousal retirement benefits. But if you were previously married for at least 10 years, you might be drawing on your previous spouse's what we call primary insurance account, PIA. So you'd lose that option if you remarried. Another thing about Social Security, at least right now, that you should be aware of is that benefits are based on state law. Many Massachusetts residents are snowbirds, and when you question them, you find out they're really residents of Florida for a variety of reasons that don't have anything to do with Social Security. And that might present a problem because Florida doesn't recognize same-sex marriages right now, and because Social Security bases its benefits on state law of the decedent, submitting a claim for survivor's benefits from Florida as a member of a same-sex marriage is going to run into problems. Fortunately, Social Security bases that determination solely on where you have submitted the claim from. So if you have any kind of colorable claim to residency in Massachusetts, and most people have addresses both places, if you are submitting a survivor's benefit claim to Social Security, you should do it from Massachusetts in order to ensure that you'll be treated under our state law by Social Security. It's not to suggest that you commit fraud, but in as much as that's all that Social Security is looking to, submission from a recognition state makes a lot of sense. The other thing, when you're visiting your estate planner or your accountant to discuss some of the options that I'm trying to suggest to you here, they can also advise you on things like IRA rollovers and options for spouses. If you've already retired before you marry, you want to make sure that if you can revisit elections for survivors and check pension sources to see if there are any issues for you. And obviously you'll want to revisit beneficiary clauses.
Time.
So who shouldn't get married? There are always downsides. For example, if one partner is on supplemental security income, what we call SSI, marriage places you in a different category, which will generally result in less income. Likewise, if someone is on medical assistance, they are treated as a member of the married couple, and the assets and income of both parties are factored into eligibility. It can be a particular issue if one of you is headed to a nursing home. Again, this is something that a properly drawn prenuptial agreement can anticipate and provide for. But if someone has a chronic disease, you want to contemplate its effect on marriage before you enter into it. If one partner has children who are about to apply for college, a marriage is going to have some impact on your FAFSA application for financial aid. Or if one partner is contemplating bankruptcy, almost certainly you'll want to go through that before you enter into nuptials. Another reason for prenuptial agreements is that surviving spouses always have an option, whether in Massachusetts or elsewhere, to elect what's called a forced spousal share. That can be fine, it's for the protection of the surviving spouse, but in many same-sex marriages, the parties each have a family that they want to ultimately direct their specific resources to. And absent a prenuptial agreement, there's no assurance that that will occur, even with a will that provides otherwise because of the forced spousal share option. So you'll want to anticipate all of these things, again, as part of your prenuptial agreement. But bear in mind that there are any number of instances where marriage can affect adversely a couple's economics, and you want to anticipate it before you enter into it. There are lots of other benefits that, to marriage that probably won't come into play with your life, but they may, and we lawyers worry about things that might happen as much as things that probably will happen. There is, for example, the spousal privilege against testifying against your spouse in criminal cases, where you can't be compelled. And the spouses are entitled to tort claims for loss of consortium and for death benefits under workman's compensation.
Anytime.
So again, when the question is asked, should we get married, my answer continues to be, it depends. But ultimately, it depends on whether you want to make that commitment. If you do, well, congratulations. I'm a fan of the institution myself. But hopefully you'll go into it with your eyes open and with the appreciation that it's still not as simple or straightforward for same-sex couples as it is for opposite-sex couples. But it's available, and with the proper planning, it can work just as well. You just need to take the belt and suspenders approach throughout. Maybe when you set up your marriage registry, you can ask for belt and suspenders.